High Court also heard arguments on the issue of the state's ban on Sunday hunting.
The lawsuit was brought by Virginia and Joel Parker against the Department of Inland Fisheries and Wildlife. It seeks a judgment that the ban on Sunday hunting is a violation of the Maine Constitution. Much of the argument pertains to the language of the Right to Food constitutional amendment established in 2021. While the Constitution declares Mainers have the right to grow, raise, harvest, produce, and consume food of their choosing, an attorney representing the Wildlife Department argues it does not apply to hunting. The plaintiffs argue the word harvest has more than one meaning.
The text of this amendment is not ambiguous. It uses general language that is not meant to distinguish between different types of food or sources of food. And the specific use of the term harvest, which is commonly used and understood to refer to hunting, as well as the inclusion of poaching in the amendment's text, are both consistent with a reading of the amendment that protects the right to hunt for food.
Because the verb harvest does not unambiguously cover hunting, we look to the legislative history of the amendment, whose drafter repeatedly assured fellow legislators and the voters of Maine that the amendment will not invalidate any hunting or fishing laws or regulations currently on the books. Moreover, when the legislature wants to enact laws that touch upon hunting, it knows how to do so, as we've seen with the many bills each session that address hunting.
Again, with this case, the justices will decide at a later